Good afternoon, everyone. Good morning to those of you in the West Coast, and welcome to our program today entitled Working Effectively with Outside Counsel, What Every Nonprofit Should Know. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. And this program, as many of you know, is part of the monthly series that we do and have been doing for the last 6 years on a wide variety of different nonprofit legal topics. We have a nice crowd here in Venable's Washington, D.C. office joining us for lunch, and we have a great crowd of about 200 folks around the country joining us for the webinar portion of today's program. And as many of you know, all of these programs are recorded and hosted on our YouTube channel, a link to which is on the last slide of today's PowerPoint presentation, along with links to hundreds and hundreds of other online legal resources of ours on a variety of nonprofit legal topics. A few housekeeping items before we get into introducing our speakers. First, for those of you in the Trade and Professional Association community, these programs are eligible for CAE Continuing Education credit. Preview of our two scheduled upcoming programs. On August 17th, our program is entitled Key Trademark and Copyright Developments Around the World, Implications for Nonprofits in China, Europe, Cuba, and Beyond. And then on September 20th, sticking with our international theme, our program is entitled How to Protect Nonprofits' Federally Funded Programs with Global Anti-Corruption Controls. That program will be co-sponsored with Inside NGO. We're very excited about both of these upcoming programs, and we have other programs already slotted for the balance of the year, and hopefully you'll be able to join us for those. A few other housekeeping matters. For those of you in the room, you have a copy of a handout book that has printed copies of the PowerPoint presentation from today's PowerPoint deck, along with full speaker bios and an additional handout material. Those of you on the webinar portion received a link to the PowerPoint slides and a confirmation email that you received this morning. And all of you tomorrow will receive an email that contains a link to the recording of today's program along with all of these materials. Feel free to share that with colleagues and others who might benefit from that. Our speakers today, I'm very excited to have both of our speakers. Actually, both of our speakers were not colleagues. Neither one was a colleague at the time we put this program together. One of them now is a colleague. One of them also is both were clients. One is no longer going to be a client for reasons I'll explain in a minute, at least not in his current capacity. But to my immediate right is Anita Drummond. When Anita and I put this program together, she was working at the Nature Conservancy, where she spent nearly a decade, most recently as Associate General Counsel. We are thrilled that Anita has since joined Venable in our nonprofit organizations practice, and this is her first presentation with us in her Venable capacity. We've done others in the past in her Nature Conservancy capacity. Anita is counsel here at the firm, a very, very experienced lawyer for nonprofit organizations, versed in a wide array of various legal topics that nonprofits face. Like I said, she spent about a decade working at the Nature Conservancy, but prior to that also had other in-house experience as Director of Legal and Regulatory Affairs at the Associated Builders and Contractors, a large trade association where we also had the opportunity to work together. And prior to that as Director of Government Relations for the American Subcontractors Association and Manager of Public Affairs for the American Council of Independent Labs. So Anita really personifies our nonprofit practice, which really crosses back and forth between the charity world and the trade and professional association world, has tremendous vantage point from the in-house perspective, and now for the last couple months, whatever it's been, from the outside perspective, and is going to be invaluable in sharing some of those thoughts and insights with you today. And to my far right is Dan Kozlowski. Dan is Chief Privacy and Compliance Officer at AARP, or at least he is until the end of the day today. Dan is also a good friend and a great guy, and is here for comic relief as well, is moving out to the West Coast, leaving to be Associate Principal Counsel for Privacy for the Disney Corporation. It's a great and exciting move for Dan. We're very excited for him, although I'm very personally sad to see him leave our client AARP. in our friendship, but I'm sure it will not be the last that we see or hear from Dan, and maybe we can get him back here to be on a future panel. But Dan is a terrific lawyer at AARP. He's been responsible for ensuring compliance with an array of federal, state, and local industry regulations governing privacy and data security, telemarketing, email marketing, social media advertising, and other forms of advertising. But for purposes of today's program, Dan has a terrific perspective on working with outside counsel. I think he does an amazing job at it. Dan actually was part of a panel that we did about a year or so ago for a bunch of Venable lawyers, giving his perspective kind of from the inside, from the other side of the fence on what he likes and doesn't like in terms of working with outside counsel. I think he's got a great perspective on it, and you're going to benefit from his thoughts and insights today. So without any further ado, I'm going to turn it over to Anita to get us started. Anita?
Thank you. So little known fact that Jeff didn't mention on my bio is that I started my life as an employee at Walt Disney World. So this will probably be the first and last time you'll ever have two Disney employees on a nonprofit panel. Yes, and if you want to know what I did, I worked in the parade, but I followed behind the horses cleaning up. So I don't know how far I've come in life, but...
Is that really on your bio?
Isn't that the job of,
not on my bio, but that's what I did.
isn't that the job of an outside counsel, cleaning up someone else's?
Exactly, but not my clients, other people's clients, right? So thank you so much for coming today. As Jeff said, I very recently come to be at the firm, so of course my bias still tends to be as hiring outside counsel and knowing some of the scrutiny that I've given over time to that, but also that I've witnessed. I had a lot of peers at the Nature Conservancy, and we often compared notes as well as with our nonprofit peers. But I am going to also be really sensitive to the fact that most nonprofits don't actually have counsel in-house counsel. And that actually, I think, is sometimes the more mysterious position to be in because you're not exactly sure how to start. So I'm hoping this will help in that analysis as well, no matter where you are with hiring counsel. The biggest part I think that's important is assessing what your legal needs are, and that can be a mystery, and I'm going to talk about that a little bit. Once you actually decide to get counsel, what are some of the considerations in drafting a scope and picking a law firm? Establishing communication approaches, and some effective cost pricing models, things that you can propose and expect outside counsel to be able to negotiate and offer as well. And then some of the reasons that these legal basics are important for volunteers and staff leadership. We're going to use some case studies to try to illustrate the points as well, and I hope this is very useful to you. Okay. Oh, so let's first talk about assessing legal needs. Assessing legal needs is something that is difficult in the abstract. That would be something akin to me saying, well, what kind of IT services do you need? And you're just sitting there and not having enough facts to know what is it I'm going to buy. Instead, you need to look around your organization and say, what are the things that I have that I want to keep, that I want to grow? And what I need there will help dictate what I need from the outside resources, and amongst those is legal counsel. So some of the big hits always is when you're in an organization and people talk about assets, people often forget the biggest asset a nonprofit typically has is their people. And if you have a lot, for instance, of turnover, you might want to stop and say, is there something about our turnover that has legal aspects? And I've used this story in the past, so those of you who want to listen to March of last year, this story is kind of the classic. A lot of good people seem to be leaving, and the exit interviews aren't really being done robustly. Maybe it's because you don't have a process for them to elevate issues that actually have legal underpinnings. That's an example of where looking holistically and said maybe we need legal counsel to come in with us and to examine we have a turnover problem. That's an example of taking an asset and really leveraging outside counsel to help you solve an operational issue that may have real legal issues, but you know it has real organizational issues, especially for your members or your mission if you're a charity. Your brand. A lot of organizations registered their trademark maybe, when we started 60 years ago. And yes, we've renewed it, but is it really current to all the uses you're using it for today? Maybe you have an amazing accreditation program, but you haven't evaluated whether you've properly protected it. And you could be so successful that others start to want to use it, do accreditation as well. Are you doing it in new markets using your trademark? And what I mean is new jurisdictions outside of the United States. So having a real assessment of what is my brand and why that legal counsel might be important later is someone does something that's really pretty similar to what you're doing and it really kind of looks like your brand. I mean, you want to have already have done your homework, but you also want to have counsel familiar with you and your organization so when that happens, you're not starting way back here. They're ready. Money. Money is obviously a big resource, and the revenue sources, I'd say, is something to always, always be thinking about. If I'm going to do something new in a revenue area, do I really have a good sense of whether that revenue source is appropriate to what we do? Does it have tax implications, things like that? Property. Oh, we want to sell our building. That's my favorite. I can't tell you how many trade associations in my career have had this asset that was a great, that I've interacted with, great asset. In the old days, it was really inexpensive, and they just sell it. And then they realize they have all these tax implications. But there could be other kinds of property, intellectual property, if your organization does research. The information that you uniquely have, whether it's prospective donors or details about your industry that is really valuable to you as an organization. Whether you're making revenue or not, it is your strategic value. Think about those assets and where those weaknesses, whether they may be evident today or in the future, and how there may be a role for different parties, including legal counsel, to help you protect those assets. Obviously, a crisis, I would say a crisis is not really an asset, but I put it on here in order to plan for the crisis. What are the things that you think are the most organizationally your biggest exposures? Do you have a certain revenue source from a very, very large grant? It has increasingly been the reason you attract new money is because that grant is well respected, for instance, a federal funder. Do you really have your house in order if there's a crisis? Corporate basics. I'm going to talk about that more at the end, but corporate basics, some people can think are pretty boring, but if you get them right and you frequently maintain things in the right way, when all those things, other things happen, like the key employee leaving, the crisis occurring, you already have people in place who already are ready for it and know how to have conversations about their legal position. If your board's never talked to an attorney until the crisis happens, you're starting too far back to effectively really deliver. So we'll use an example of that when we get there. So let's give us just a quick couple of examples. So you're hiring your first employee in California, never worked in California. That's an example of a little light bulb should go off. People, you're growing your people resources. California is not Virginia, as an example. California is very different. That's an example of having your radar up. You're going to increasingly rely on grants from a European multinational organization. Maybe in the past you've gotten a small amount of money, and it's a really big contract, but it's worth it for that little bit of that money. It was seed money, but now they really like what you're doing, and they're going to ramp it up. Well, this might be a really good time to step back and thoroughly examine that grant agreement if you didn't the first time. And trust me, I was in house counsel for many years. Cash can be king, but slow down and get it right so that you can grow that pie of money over time and you're doing the right things. You want to offer new service to individuals, and it's a revenue source, but they're not qualified to be within your association's membership. You should have an evaluation of that to see if it has any tax implications for that revenue. Those are just some basic examples of things that should raise your radar. Here's an asset we're growing. like employees, getting more money, trying it in innovative ways. So we're moving outside of our basic corporate, structure, the box that we've been working in. Slow down and make sure that you're maximizing those things for your value. And outside counsel can really do that. Dan, did you have any?
Yeah, so the last example, this is obviously the area that I have focused in. I think one of the things we wanted to point out is a lot of times you will have a situation where there's something happens with your IT systems, someone has, access them, there's some unauthorized access, there's some loss of data, something, and you immediately think, okay, we need a forensic IT expert, we need some, this is a technology problem, which is true, it is largely a technology problem. But unless you want whatever that forensic investigator or auditor, whoever it is that's coming in to help you solve this problem, unless you want that to become public, you may need outside counsel as well in order to help you manage that. So we'll talk a little bit more about the value of having outside counsel oversee sensitive internal investigations or audits or forensic work. But sometimes people think, oh, this is an IT problem, and that may be true, but it's also a problem that a lawyer can help you solve. And keeps that part of it quiet if you need to.
Right.
By the way, I forgot to mention at the outset that in terms of questions, we feel free and we encourage you to ask questions throughout the program. For those of you in the room, just raise your hand and wait for one of the microphones to come to you so everyone on the phone can hear. And for those of you in the webinar, just pose your questions to me using the chat feature on the webinar software, and I'll post them to our speakers.
So the next slide is about kind of scoping the work from the outset. And for those of you who have the benefit of having in-house counsel who work for you, this is where they should be showing their value. They may not be able to do the work or the research. It may be too big of a project. They may not, they may be more of a generalist, but they should be able to help you and help the organization at least determine what it is, what outcome do you want to get from your outside counsel, and to help communicate to that to them. For those of you who don't have in-house counsel, this can be something that can be hard to get right the first time or at the beginning, and you should have outside counsel that help you do this. But either way, you should have an idea of what you want before you engage outside counsel. I wouldn't just call someone and say, even if doesn't end up being what you're doing, have some sense of what it is that you want the product to be, whether it's a report or just some advice, and what the timing should be. So we'll go through each one of these. Urgent or long-term, this is really just about timing and when you want it. And this is really a key issue, and this is often where there's a lot of issues between organizations and their outside counsel, because everybody wants everything right away. Do you really need it right away? Do you really want, the truth is you can, outside counsel want to please you. They want to keep you as clients. But if everything you send them is a firestorm at the last minute, you may not get their best work. I mean, they're human beings. They have families and lives outside of work. The more you can respect that, and there are times, of course, where you can't and things come up, but you're not going to get their best work at midnight on Christmas Eve, right? So if you want the best, and that's just human nature. So I try to really give our outside counsel really reasonable, clear deadlines. And it's okay to give 2 deadlines. So we would like to have this by Tuesday. We have to have it by Friday. And what I have found is 90% of the time they get it back to me by Tuesday, but it's comforting to them to know that they've got a couple extra days if they need it, and we're not just making up a deadline for them. So that's really key. Really determine when you need to get something back. It'll help your relationship with them, and it'll help you have expectations that are met. One-time fix, long-term implications, or process-oriented. This is really where it's a situation potentially like Anita was talking about, where you have one employee who has left. It's a high-level executive, and you want to know what the legal issues are around that. Well, that's a one-time situation. Or is it more, like Anita was mentioning, you have a bunch of senior executives or a bunch of employees are leaving, and you want to know what the legal issues are around that, and is it more systemic? Is there a process problem? Is there a problem in your HR department, something in the organization, and what those risks are? So you want to kind of know, and it could be both. It could be that this one executive leaving is the canary in the coal mine. You're not really sure, and you want to talk about it. But be clear about that. Be clear with outside counsel that we really just want to know about this one person leaving, and maybe they'll come back and say, well, actually, maybe it's indicative of a bigger problem, and you can talk about it. But just make sure you're both on the same page. Risk management in an existing situation. This would be, you've trademarked you have a trademark that was, registered in 1945. You may have changed the scope of your work since then, you're doing all sorts of different things. You might want to have that checked out. Or is it, your trademark is fine for what you're doing, but now you're thinking about expanding to 5 different countries, and so you may need to register there. So that would be something where you're talking about growing internationally. Geographic expertise, this is something that people really miss out on. So I started my career as a trial lawyer, a legal services lawyer. And so having lawyers that know the individual jurisdictions that you're litigating in, and litigation is key. It may not be as complicated if it's just a contract, but you do want to know, what experience does the outside counsel have if it's international in that country, if it's a state law in that state, and if it's something like litigation or a regulatory action, what experience do they have in that specific court? And it can be court to court. It can get that, that kind of pinpoint and that specific. If you're, I don't know if you guys have ever seen Michael Clayton, the beginning of Michael Clayton when George Clooney gets called by some, he's like the law firm's fixer. He was their kind of street lawyer, and he gets called by an executive from a really important client, and he just ran over some guy while probably a little inebriated, and he doesn't know what to do, and he's looking at probably a negligent homicide charge. Clayton shows up at his house and he says, you need a local guy. You need a guy who knows the courts here, who knows the cops here, who knows the DA here. It's not always that extreme, but sometimes it is. When it comes down to litigation, if you're being prosecuted by a state AG, you want to have at least one lawyer on the team who has dealt with that state AG before. You don't want to have someone who's just, well, we've dealt with the Justice Department. Well, it's different in Arkansas or whatever that state AG is. It's all different. So getting that specific expertise is important. Affiliates or related entities, you want to have some idea or at least talk to the outside counsel about the role of your affiliates or other related entities, and whether this work is, whether what they're doing is within scope, and find that out, because there are issues about attorney-client privilege. Sometimes the privilege can apply, sometimes it doesn't. If you're trying to keep this, confidential, then that can be important. And you also just want to let them know that they exist, because if they're analyzing tax consequences or something for a 501c3 and you've got an affiliated, taxable entity, it'd be good for them to know that. And like I said, the expected work product, I once hired outside counsel, and it was just typical. It was a kind of a standard request, and the standard practice was at the end of it you get this memo that just kind of tells you about all the, stuff. And I always tell them to put the stuff I really need to know in red. And then you read that red part, and then nothing else. It's a good thing it's my last day at my job, and I hope no one from Disney is listening. If they are, I stopped that practice years ago. But this law firm didn't give me a memo. They just called me and told me all the problems, and I'm frantically writing things down because I wasn't clear enough with them. So be very clear about what it is that you want. And then budget. We'll talk more about that, but it's hard to know how much things are going to cost. I mean, it's like shopping for health care. You have no idea what it costs until it comes in, and the prices can vary. We're going to talk more later about that, but have some sense of what you can afford, at least going into it, even if you don't know how much you're willing to pay for it yet. I think I have the next one, right? So this is a case study. This is another area that's kind of technology related. And just very quickly, this comes up all the time. So you're acquiring some new technology solution. You're operating internationally. There's going to be donor data transferred across borders. You're letting your IT director kind of handle it, and you're thinking, well, we should get some lawyer to look at the contract. And that is important, but you also want to know a number of other things. If you're collecting information from donors in Europe, for example, the EU has a bunch of really strict laws about transferring data from their citizens back to the United States, as do a bunch of other countries. So you want to know the implications of that. And you never want to do a quick review of a technology contract if it's an important technology solution, because if it goes down, you want to make sure that contract has very clear service level agreements, things about what happens, what is the security and privacy practices of this vendor, whoever is managing. It's, software and technology solutions now are often provided bundled with services, so it's not like you just install Microsoft Office on your computer and then that's your relationship with them is done. There's a lot of hosting and other activities that are done by the vendor ongoing, and if they're not protecting that data, all of a sudden your donor data is gone, it's been stolen, You can't recreate it. It's in the hands of your competitors, those types of things. So you want to have an attorney experienced in that field help you vet that vendor and negotiate that contract and advise you of all the implications. And then, you want to switch to the next one?
Yeah, I just wanted to make a few comments on that. I want to make a few comments on that. Some of the things is obviously urgent versus long-term. It depends on when you are now in a position to need to get counsel. A lot of times, if obviously someone had to probably put in a budget for that at the board level, that's when the budget comes in. It shouldn't just be for the product. It might even need extra people to help implement it, but getting legal counsel to actually write the RFPs for big asset purchases is probably one of your best moves to save money, because legal counsel asks you all those questions Dan just asked, and the contract gets very complicated because now the vendor is like, well, I didn't realize you needed that level, and let me go back. And so your organization's done a whole lot of work to purchase something, and now people are trying to thread a needle to just get this vendor because we've put all this time and effort already into getting this vendor. So I would say if someone's budgeting early, going to something especially that goes to the board, there should be some idea, if this is a major asset, what are the other implications for that? And legal may be one of those, legal counsel. Other things might be, you know, we're going to hire a project manager to transfer all the data. So sometimes people are thinking that and sometimes they're not. But waiting at the end for the contract to be reviewed for major asset purchases, I can tell you, buying servers was far more complicated than we could have ever imagined, right? And as an example, so think in those terms. We're doing something big. What else has to turn in order to deliver that asset?
And just to elaborate on one of Anita's points, we're big in our nonprofit practice. We're big believers in using that RFP process when you have the maximum amount of leverage to build in a lot of the things that you might otherwise have a tough time negotiating when it comes to negotiating with the vendor who you already selected. And so having legal counsel involved early in that RFP process can be invaluable in helping to give you leverage that you might not otherwise have.
So now we're going to talk about what to think about when you're hiring outside counsel. And this is really kind of probably in my opinion, since it's my slide, the most important slide in the presentation, and probably where I have spent a lot of time trying to kind of hone this. So I never worked at a law firm, and so when I came in-house, I had very little knowledge about the inner workings of law firms, which I actually think helped me because I really didn't respect them, because they're not always in your interest. I found out the hard way that some law firms don't like that. Venable is not one of them. They've been great about it, which is why I'm here. But it was really an eye-opening experience. They're very hierarchical, big law firms, and they sometimes don't like you calling associates directly. Who knew? And so lots of things like that kept bubbling up. They don't like you asking a lot of difficult questions sometimes, and those are all bad signs. So shopping for outside counsel is like shopping for anything else. You know, a lot of it is common sense. You do due diligence, you meet with them, you talk to them, you get a feel for the attorney, you get a feel for how they present. Are they asking you questions? That's always a good sign. If they never ask you a question when you're starting your conversation with them, that's really bad. It's like a bad first date. Like if you just spend 90 minutes and, and the other person didn't ask you a single question about yourself, that's a bad sign. Same thing with outside counsel.
30 minutes in. I knew we were going to get to the dating analogies. You always get there, Dan.
There's worse analogies coming. Don't worry. So you want a lawyer counsel who knows your organization. The only way they can get to know your organization is by asking you questions. I always find it very impressive when I show up for the first meeting or the first call, and they've looked at our website or read our 990 or done some work on this ahead of time. The most impressive presentation I ever saw from an outside counsel was a pitch for litigation, and they had already come up with an outline for the motion to dismiss. I thought, well, that's pretty, and it really was substantive. That's pretty impressive. So they want to if they want to get to know you, they want to understand what your concerns are. That's a really good sign. You obviously want to know if they have expertise in this specific area. Now, most big law firms are pretty full service, but Some of them are better at it than others, and individuals vary, right? So the head of that particular practice of that law firm may not have the best practice area, may not be the most skilled attorney in an area. I mean, most big firms are going to have good lawyers in every type of practice. But there are times where, you can run across, you can have a great one firm that's great in everything, and then all of a sudden their trademark work, and you're like, well, this isn't very good. So you want to drill down a specific thing. If it's litigation, like I said, ask difficult questions. If it's a trademark issue, what is your trademark practice? How many trademark lawyers do you have? Who specifically is going to be working on my project? That is one of the things that you don't realize, and I didn't realize, is that you'll talk to an attorney, and that's not the one who's going to be doing the work, and you don't know who is going to be doing the work. You want to know that up front, and you want to see their bios, and if it's a big project, you really want to talk to them. And I'm talking down to the associate level. If it's an important project, particularly if it's a litigation, where the associate's going to be doing a lot of the work, you want to talk to that associate. I mean, I do. I would never, for a major project, hire a firm without having at least had some conversation with the associate and understanding their perspective and seeing their experience, or at least vetting them a little bit. Because even though the partner may be supervising them, they're still going to be doing a lot of the work, and you want to make sure that they understand the organization and that they're competent in their area. Experience with specific implications of a nonprofit, that's important. It may be less important for things that are kind of generic across different organizations, but that's pretty rare. You really do want lawyers that have had some nonprofits as clients and understand the issues related to you, because they can be very different. And they cannot just be legal issues. Understanding the resource limitations that nonprofits have is important. Understanding that the staff is much smaller, that they often don't have in-house counsel. Those are all important things to understand. You need a lawyer, if you don't have in-house counsel, who can communicate with you in non-legal mumbo-jumbo. If you hear one Latin expression in there, that's, you should probably stop and say, hey, can you talk to me about this in a way that's not full of jargon. References, I mean, that speaks for itself. You definitely want to check references. You'd be surprised. It's like people blow off job references, but they're meaningful. And the law firm is going to give you clients who clearly they think like them, but like is a spectrum. And also it's subjective. So they may like certain things about that law firm that would make it something you don't like. I'm trying to think of an example now, but it may be that, or it may be something they really like about them that's expensive and just not that important to you. So you want to actually talk to those people and be able to ask follow-up questions. You may not need to do that for every project, but if it's a big project or you're thinking about retaining a firm to be your kind of principal outside counsel, you definitely want to do that. You want to find out what their kind of planning is for all sorts of things, like legacy planning. You're working with one partner. Maybe it's a small practice. Maybe there's only 3 lawyers in the nonprofit division. Not a problem at Venable, but maybe a problem at some other firm. One of those lawyers leaves, or something happens to them. What's the plan then? Who's going to take over? Things like security. This isn't critical for everything, but if you're asking a law firm to do something very sensitive for you, you want to know what their security practices are, because somebody breaks into their system and you're going to be humiliated. I mean, what's the law firm in Panama? I can never remember the name of it. That's exactly what can happen. So you would think a law firm like that would spend some time securing their infrastructure. But apparently they didn't spend enough. Although I think it was an employee who walked out with it. But there are things they could have done to prevent that as well. So you want to ask about those things. And this is something that is not on the slide, because if I had tried to put it on there, they might have told me no. So I'm just going to bring it up myself. But you do want to know a little bit about the culture of the firm, particularly if you're hiring them on a retainer. If people hate working there, if all the associates are miserable and they're unhappy and they're working 16-hour days every day and the partners treat them terribly, they are not going to give you your best work. Now, they may be brilliant, and so their 80% is good enough because they went to Harvard Law School, but that's not ideal. And to constantly be taxing people to the level where they're working at exhaustion levels, you're not going to get the best quality work from them consistently. And that's when mistakes happen. And I firmly believe that. I really believe, and it's part of the reason why we've used Venable, is that they tend to understand that. because there is, I have found that when I talk to, and I call associates directly, and when I talk to them, they're very responsive, but they also seem very engaged in the work, seem to have more ownership over the work, care more about your organization and the quality of the work because they see the connection, and that's important. Lawyers are people. I know it's hard to believe, but we are people, and we're subject to the same, very subconscious biases and other things that can affect our quality of our work even when we're not thinking about it. And we get tired and we make mistakes. And I think that having kind of vetting that and seeing, you can even, if you're really concerned, you can even go, there's plenty of websites where associates will anonymously tell you what it's like to work at that law firm. And you can go and look on those. And if everybody hates it there, that's not a great sign. It doesn't mean you don't hire them, and it's one factor to consider. So I think that's kind of,
Okay.
pretty much covers what I try to go through. Again, a lot of it is common sense. Do you have a good feel for them? Are they asking you questions? Are they engaged with you? Do they seem concerned about the outcome, or are they just kind of telling you? Is it like a bad doctor when you walk in a doctor's office and they sit down for 30 seconds, like, here's what's wrong with you, here's what I'm going to do, and then they walk away? You shouldn't have that feeling in consulting with outside counsel for the first or second time.
Thanks, Dan. We have a couple of questions from the webinar that are relevant to this slide, and I'm going to change this first question a little bit. But basically, how do you go about finding outside counsel with relevant expertise? And this question is for either or both of you.
Google. I shouldn't say that, but search engines. It can be difficult. So if you have in-house counsel, that's one of their key jobs. If you don't, I really do, what I will often do is, and since I am in-house, I do this myself, is I will actually, and maybe I'm giving away one of your secrets, Jeff, but I will search for that term. I use internet searches all the time to do legal research. All lawyers do it. But I will search for the very specific issue that I'm trying to solve for, and a lot of times you'll see materials come up, and you may see, like a presentation that comes up. And this is why doing things like this is effective, because I'll see, oh, wow, this law firm thought this was so important and had enough concern and expertise in this area that they did a whole seminar on it or a whole day conference on it. And I'll call them. I'll just cold call them if I need to. So that's a good way to do it. It really is just like searching for anything else. That's generally how I do it.
You're right, and we get this all the time.
Yep.
If a law firm has 10 articles and 25 speaking presentations on a given topic, there's a pretty good chance that they have a lot of expertise in that area.
Trade associations.
And we get hired and found a lot from that sort of. In fact, there was this one guy, general counsel for a large Fortune 100 company, that we actually do a lot of work for the company. But he didn't really know that we had a nonprofit practice, and he does a Google search for commercial co-ventures because they were going to enter into a commercial co-venture with a big charity, and he found us, and sure enough, he hired us to do that sort of work.
Yep.
The second question is, do you have recommendations for managing multiple outside counsel firms who have different areas of expertise?
Excel. Spreadsheets help. We have a lot. We're one of the biggest. Well, Nature Conservancy is too. We're two of the largest tax-exempt organizations in the country, and we have a lot of different outside firms. It can be tough to keep track of them. Other than from a logistical perspective, if I understand the question correctly, I think there is an issue about even just when they're overlapping areas of expertise. And so we, for example, use Venable for certain things. We don't for other things. There are other firms that we use for certain types of work. And if those issues come up, if law firms ask about them, my practice is to just be very blunt with them and tell them the truth. Sometimes it's just that this firm has been doing our trademark work forever, and I'm not the trademark lawyer, and I don't get to make that decision, so I'm happy to connect you, whatever, but we can't do that. I can't make that decision. Or there may be certain, benefits using other certain firms for certain areas, or I will directly say to a firm, we didn't think you were made as great a pitch on this. For this other work, we're really happy with the work you're doing now in this area, but it doesn't mean we couldn't open the door later, maybe develop some more expertise in this area, things like that. I think if you can't be honest and direct with your outside counsel, you need new outside counsel. So that's my approach.
Anita, any thoughts?
I would say, I was laughing at the Excel, to on a periodic basis evaluate, go back to what are your real legal needs organizationally, and say who's serving those needs and whether you're spending a lot of money on one firm doing something that's become less important or less risky, and you can consolidate it into something else. That's not about dissatisfaction necessarily, but it's about resource management. It takes not only resources of dollars, but it takes so much staff resources to manage multiple counsels. So you really have to keep all the balls in the air and make sure, and a lot of times they can turn to overlapping. A really good example is trademarks. If you have trademarks in one place, but you have someone else doing your, say, cause-related marketing work, those things really do come into play, especially if you're moving outside the United States, because trademark licensing is very different by country, and having someone who really understands how to put together the tax issues, the international revenue issues, and the trademarks, and you have firm doing it cohesively, then you may only be talking to one attorney for a lot of things because they already get your trademark portfolio, even though it's maintained by maybe a paralegal in the IP section of the firm. So it's an analysis. That's what I would say.
Yeah, and then if you're really struggling to manage your kind of portfolio of outside lawyers and it's grown too big for you to manage yourself, maybe time to hire an in-house lawyer to help you do that, because that's one of their key jobs.
And it also may be time, I won't name names, but we're excited to have our newest client here today. And this organization was working with, I think, 36 different outside firms over the last few years, and decided to do an RFP to consolidate, ideally, into one firm. A lot of times those relationships evolve through historical legacy. Other people knew someone, and that's how they get hired, and they're not always the most effective counsel. And so periodic reevaluation, doing an RFP, and this has happened with us because we do have this kind of one-stop shop kind of structure where we can serve as that one-stop shop for all of an organization's legal needs. I'm not saying this as a pitch for Venable, but that efficiency that comes with kind of putting everything or most things under one law firm roof, and the effectiveness, like Anita said, to have one firm, one set of lawyers that understand the tax exemption issues and the trademark issues and the international regulatory issues and all of those things that might come along with doing some transaction overseas where you're licensing your marks and earning revenue and whatnot. It's just almost impossible to get that from having multiple different firms doing that. So you're going to get a higher level of effectiveness and a much higher level of cost efficiency. And our new client is going to be spending less money and getting much more bang for the buck going forward.
I want to make a point on the last bullet, which is reserve. When you're thinking about engaging outside counsel, obviously a lot of nonprofits keep a reserve for unexpecteds, but having a look at your insurance policy and even have your outside counsel help look at your insurance policy, you'd be surprised how many people forget they have insurance, especially on employment issues. So it's good to know that you should know that your insurance, what it has available, or to have your counsel help you negotiate for follow-on years better coverage on your insurance, and then your law firm can negotiate a rate with your insurance company if in cases of crisis, something a lot of nonprofits overlook. So the case study that we're going to talk about now is a longtime vendor that provides your nonprofit with online training platform, and they're proposing to change the contract. They want to create a new revenue sharing model. And now you want to engage outside counsel. So let's theorize that you believe this is not an urgent issue, and you come to your law firm to get some advice on this new proposed contract. I always say, how close is the other contract to being up? Is it really urgent? You should have, this is a good comment you made about the questions, is your lawyer should be asking other than, oh, this is what I think about the contract and giving it back. They should ask, is your contract you have now like quickly expiring? Do they have leverage over you? Are you making the money and they're not? I mean, what is it? Where is the place they're coming from? Because that gives the lawyer context on you negotiating with them, or whether there's any relevance to having a lawyer negotiate it, because sometimes that can escalate attention. But that's the kind of thing when you're thinking about the scope. I said, is it urgent or is it long term? It may be more urgent than you think, unless somebody's asking the right questions about what that vendor is doing. a different kind of question would ask is, when you're thinking about money and budgeting, how important is this particular activity to you? Are you making money? Are you collecting critical data about your members even though they don't pay for the service? Do you have affiliates that are relying on it for some revenue? So that helps you think about how much is this worth to me to go to outside counsel. Changing a revenue model, however, can have implications for a nonprofit, hence why having a counsel that's sensitive to you as a nonprofit helps. So you asked what a law firm gave you that you didn't want. Well, for me, if a law firm gave me a giant memo, my head would explode. I just want them to quickly tell me on the phone, right? So I bring this up because let's say this contract came in, you're thinking, we're good with this vendor, I don't know where this is coming from, and you show it to your counsel. Your outside counsel should be saying, well, let me just give you a heads up about the way they're proposing the revenue. It may be taxable to you because they're trying to create a joint venture, but you're no longer controlling. So is that even where you want to go? So you can get a quick answer that saves you from making a mistake of signing, oh, we just need to keep this contract going because this service is critical to us. But you may say, no, this is a huge source of revenue for us. And okay, do you want to keep working with this vendor? Yes, we do. Maybe you can make a joint venture, but you want to make it in the right way. So getting a quick answer doesn't mean you're going to get the full answer. Quick is not always best, but at least you can catch things like, wow, this could be a taxable activity if you change the structure of this contract. And maybe that's all you need to know because you're going to go back to the vendor and say, no, we're not interested in the whole churn of changing this contract structure. And you at least know what your negotiating position is at that point. But it's an example of how do you scope outside counsel. You don't have to sit down and do a whole rigmarole of like a detailed proposal for looking at my contract, but you do need to have a counsel who can have a good conversation to answer some basic questions about how valuable is this to you? Is this vendor holding it over your head? What is its value to you to help me help you scope how much time we're going to spend on this contract?
And having outside counsel who not only has experience in negotiating and reviewing these sorts of technology transactions, which are very, very commonplace for every nonprofit, but also understands kind of how these things play out in the nonprofit world and has that practical experience. For instance, we review hundreds and hundreds of technology-related contracts for our nonprofit clients every year, and our clients generally remark about how valuable that insight is, the best practices, the benchmarking, and there have been countless occasions when later on there were service issues and other problems with the vendor where the provisions that we helped suggest that to be put into the contract to help protect the organization ended up saving them tons of money down the road and a lot of headaches.
So we're going to go to another case study, not contract related. A longtime senior manager at your association is not promoted to an executive position. They begin to complain to HR, to other employees, to members, and they say that the board chairman doesn't like them, right? So I have to scope my legal services, right? So, So, are any assets affected here? Obviously the employees. But who else is affected? Who are the critical? For me, it's the board, right? You have all these volunteer leaders, and now they're going to be now brought in, right? And I think recognizing that and knowing, wow, this becomes urgent. It's just not because this person, she's really valuable, she's done a lot of great stuff for us. That's just how she is. That is probably the wrong approach. What's really critical is recognizing I have a lot of assets that could be at risk, and the assets really are, I hate to say it, time and aggravation of volunteers and other executives. And if you can help systemically address it, then you prevent the longer legal drain that may be in the future. So you're now dealing with outside counsel. Ideally, this counsel is someone you've planned, you have a corporate relationship with that counsel. They already know who the board, any the key board member is. They already know you or your HR director. They have a working relationship. This will help you. So going back to the very first thing where have I assessed my assets and am I protecting them, you want to have a counsel that already knows sort of the lay of the land. So when things like this come up, it's more expeditious and it hopefully will be resolved in a more amicable way and you don't drain your organization first of time and effort. Enthusiasm gets lost because they're dealing with something, possibly a litigation. Of course, outside counsel is going to ask you, and they should have experts available to you if it's not your main relationship person, to ask all the right questions about that person's protected status, what the scenario was, how you hired them, all the things that you can imagine that you would do in an employment situation. But if you jump right to an employment situation with an expert outside counsel on employment, it's important they are asking the right questions about these relationships, like with board members. They often don't have a real sensitivity to the intimacy that often occurs between, and I mean that in the relationship sense, of board members and, high-level employees. So someone who has a lay of the land of your organization. Also, what if this person is like the director of your chapter relations? I really want to know what they do for you because that will affect sort of that cascading effect of the complaining, right? So that's the good questions that good counsel should ask. And you should, again, to emphasize the answer, you should expect counsel to be asking you those questions. The first question isn't, oh, is it someone in a protected class? Like, where does this person fall within the whole organization, and how does your organization address issues if this was raised before and so forth? So, is it process-oriented or one-time fix? Well, let's hope you have a good process, right? A one-time fix may be immediately what you need to do, but if you have good counsel, they can make recommendations to improve that process. If this person is in certain jurisdictions, they may have extremely elevated rights beyond what you may think of, especially if they're in certain states or that have a high level of for-cause, non-promotion. Outside of the U.S., completely different ballgame. Completely different ballgame. I already talked about affiliates. What form should your advice take? We talked about this. What product do you want? I would say that keep that fluid, even though you may have an ideal. You think, ideally, this is not going to cost me much. You're just going to tell me what to do. I would say keep that communications open, keep counsel fully informed, and keep in mind you have attorney-client privilege if you're working with outside counsel that you will not enjoy for anything you're doing outside of your conversations and your emails and your communications with outside counsel. So everything you do in a complaint situation could build up to something. And what's the budget? That's why I mentioned the insurance before. There you go.
So I'm going to talk about communications. I've already hit on some of these things already, but this is another, I think, key area. Like every other, like your doctor, your exterminator, your, I know no one's going to complain about comparing lawyers to exterminators. Any other professional.
Cleaning up portions.
Yeah, that was pretty bad. Any other, your mechanic, whoever it is, if you don't have good communication with them, that's not going to be a great relationship. And outside counsel is obviously no different. And so, we talk about establishing those expectations up front. What do you want from them? I just negotiated a retainer with a firm to help us cover an employee absent, and we have service level agreements in there. So if we get them, or it's a lot of small requests, if we get them to them by a specific time, they have to respond that same day or in a later time, and it's very detailed. And that was the expectation, and they met that expectation. It wasn't quickly. It was specific time. And so we cover all of that in a lot of our retainers, particularly for individual projects. Voicing concerns quickly, this is obviously very important. Do not let things linger if your outside counsel is not getting you things by the deadline, the first deadline they blow through, they should never blow through deadlines unless there are extenuating circumstances or you're giving them unreasonable deadlines. But if they have agreed to a deadline and they don't meet that deadline, that's a big red flag. And worse, if they email you ahead of time or call you and say, hey, I'm so sorry, we're not going to meet this deadline, this came up or this came up, whatever, can we extend it? That's fine. But if they say, we'll have this to you by tomorrow at 5, and then it's 2 days after that and you've heard nothing, that's a big problem. It's just like with employees or anyone else. You would not permit that from other people. You shouldn't allow that to happen with your outside counsel. A big thing that's come up for me a lot because I didn't work at a law firm was who do I communicate with at the law firm? And so law firms have these relationship managers. I call them billing partners, which is not the term they want to use. But for example, Jeff is not our relationship manager, I don't think, right? See, I don't even know anymore. There's a different attorney there who's a very nice guy, but sometimes I email Jeff directly, and he's okay with that. And it's Jeff's job to loop him in. It is not your job to maneuver through the internal politics at your outside counsel's firm. That's their job. So in one case, I called an associate one time. The partner who was managing that project called me back and told me not to call the associate directly in fairly unpleasant terms. I have never used that partner for any project ever again and never will. And I don't as long as I ever work anywhere because it was totally inappropriate. If I can't talk to your associate, that's a problem. I understand maybe you want a heads up. Maybe you want to be on the call, whatever it is. But if I have a question directly for them, I want to be able to talk to them. And if I happen to mess up your internal politics, I'm not to blame for that. That's you. That's on you for not clearly communicating that. So you shouldn't be getting scolded by your outside counsel for communicating with the wrong person. They should be helping you manage that. They should make clear what their expectations are from the beginning. If they say, always please initiate with the relationship manager, there you go. But if they don't tell you that, how are you supposed to know? If you have in-house counsel, and if there are in-house counsel who are participating today, one of your key jobs and one of the key things you have to do is manage communication with outside counsel. So you do not want to have everyone in the organization communicating with the outside counsel. And frankly, even if you're not in-house counsel, if you're the COO or whoever you are, whoever is responsible for hiring and managing that relationship with outside counsel, you want to do that. You do not want to have 5 different employees or board members contacting your outside counsel directly. Your bills will skyrocket. The outside counsel will be confused about what's happening. People won't have the right information, and you won't get the best advice. And you should make that clear of your outside counsel, and they should respect that. If you say to them, I am the person you communicate to about this, and they start taking calls from other people and emailing them and not telling you, that's bad.
And one modified version that we see some of our clients do is have one person who's kind of the gatekeeper.
Right.
Sometimes in some of our clients, that one person is the primary funnel of the new issues, requests, contract reviews, etc. But in some other cases, that person's not always the funnel, but they have to give the okay before someone else on staff calls. So sometimes it's just more efficient to have the vice president for chapter relations be the one that's contacting the outside counsel with the issue that they need advice on.
Right. But if you're the executive director of a trade association and you say to outside counsel, I want to be your primary point of contact, and one of your board members calls them directly and they answer the call and give advice to them or send them an email and they don't even tell you and they don't respect, that's bad. I mean, that is a reasonable expectation of you to say to your outside counsel.
I couldn't agree more, and it's generally a very bad practice for board members to be contacting legal counsel directly, with one exception, and that's when there is an issue involving the CEO, him or herself. And we do deal with that, unfortunately, a lot, whether it's a performance issue or a planned termination or something, or even a contract renegotiation. That's generally the only time that it is appropriate.
All right, so now we're going to talk about money. And not surprisingly, that's Jeff's slide.
And it's good time because we just got a question. Could you discuss how retainers get structured? Is it unlimited hours per month or caps on hours? And what is the average hourly rate for a law firm services I should consider? I don't know if I can go there, but let me talk a little bit about these issues. So first off, I would say that every nonprofit, and certainly every one of our clients, and we represent about 700 of them every year, no matter how big, and some of them are some of the biggest nonprofits in the country, are extremely fee sensitive. Whether you're a charity, a trade or professional association, a foundation, a museum, a college, a university, no one wants to spend tons of money on outside legal services. That's just simply the reality. And so as outside counsel, if you want to work with nonprofit organizations, you have to be very cognizant of that. You have to be very efficient and cost efficient in how you operate. Regardless of all of this that we're going to talk about here for a few minutes, whatever structure the billing arrangement takes, you have to be very efficient. And frankly, even generally we discount our fees for our nonprofit clients beyond what we would typically charge to, say, a Fortune 100 company. That's just the reality. We don't have any choice as a big firm to be competitive. We simply have to do that. Secondly, I would say that we have a wide variety of billing relationships in place with our different clients, and a lot of times it's a kind of a mixed bag even with a particular client. So we have some clients who have us on a fixed monthly retainer where we have a flat set amount, and it could vary anywhere from a few $1,000s a month to we have some maybe up to $25,000 or $30,000 a month, maybe even some I think a little bit higher, up to $50,000 for some very larger organizations. And we will work with our client to kind of negotiate and scope out what is covered by the scope of that fixed monthly retainer. It works well for some clients in that it gives them budgeting certainty. It also makes them less afraid to pick up the phone or send an email worrying about the clock, ticking, ringing up fees for every little phone call. So they tend to use us more and more comfortably and with less apprehension. And it can work well, particularly in situations where we are kind of the primary outside counsel firm or even general counsel if there are no in-house lawyers. Of course, we have to carve out certain things, most importantly litigation, from that fixed monthly retainer. Sometimes we carve out other things like trademark registrations and certainly out-of-pocket fees and things like that we might incur on behalf of the client. And then we will generally try to keep that in place for at least 6 months, sometimes longer, but usually 6 months, and then mutually reevaluate it to see how are we doing kind of against that. Because some months, it always happens, we go over that cap, and some other months, maybe say in August, we go under the cap, but we're still billing that same fixed monthly retainer. And that can really work well, and some of our clients that we have that relationship with, we do adjust that number up and down over the course of a year or multiple years, but it works really well for them. At the same time, I would say the vast majority of our clients prefer to simply be billed on a straight hourly basis, of course with whatever fee discounts that we have in place, but just on a straight hourly basis with obviously very detailed time records of all the work done by attorney, by day, with detailed descriptions. And easily the vast majority of our clients are on that sort of a structure. But oftentimes mixed in with that, it is very common these days for our clients to ask us at the outset, or sometimes even to tell us kind of what level of review or work do we want for this particular project? Because we can scale our work as a law firm in lots of different ways. We could eyeball a contract and take 15 minutes just to spot any very significant red flags and then have a phone call with the client to talk those through, and that whole process can take less than 30 minutes. Is it going to be a detailed review of one of your most important contracts? No, that's not what I would recommend for a situation like that. But for something that maybe doesn't have a high dollar value or doesn't have critical intellectual property issues or brand protection issues or whatever else, tax exemption issues involved, that might be all that you need. But you have to have that conversation with your law firm at the outset to give them that direction. And the clients that we've worked with over a longer period of time, many of them have gotten very good when they send the initial project to me from the relationship partner to let me know at the outset, this is our major conference that we have every year. It's our major revenue generator, the contract with the convention center, the contracts with the hotels. This is really important to us. We need kind of a deep dive. We're a major technology transaction, acquisition of a new system for us. It may be worth that you need to spend a couple hours on it. But my point is having that conversation at the outset can be especially helpful. And if we can if there's a definable beginning, middle, and end to the project, then we will and often do agree to either a fixed fee for that particular project or a cap. We often get asked for, what do you estimate the fees will be, and we'll give a range. And barring any big surprises, we're generally very good at keeping the fees kind of within that range. And if we go over, we'll write off the difference. So on a kind of per project basis, even within the scope of hourly billing, you can and should negotiate with your counsel, at a minimum get fee estimates at the outset and give direction as to the scope of work that you want and the deliverables. That has a big impact, of course. If you need a written memo, versus a 15-minute phone call or a short bullet-pointed email, that can have a big effect on the cost. But you have to have those conversations at the outset. And if your law firm is the right fit for you guys, you'll know because they'll work with you and they'll be accommodating. And if they say to you, no, we just can't do that, we have no idea how long it's gonna take or what it's gonna cost, you may not be working with the right firm. We have something in here about timely billing. That should go without saying that you're gonna get your bills for the work done in the prior month, and there's not going to be delays in that. At the same time, sometimes when we have a project where the deliverable hasn't been delivered to the client yet, we'll actually hold off on billings. We don't want to send the bill until we'll defer the fees into the prior month or two. I'm not sure what we meant by general counseling value.
So that's I think that was that's cost versus value, right? So if you have a lawyer that charges $900 an hour, but they can answer a question in 10 minutes off the top of their head, isn't that cheaper than a lawyer charges $200 an hour and needs to spend 6 hours of research and calling the IRS?
Yeah, no, it's a great point. Venable's a big law firm. We have 650 lawyers across the country. As you would expect, our rates are going to be a bit higher. They're actually a bit lower than most other big law firms, virtually all big law firms, but they're going to be higher than a small firm or a solo practitioner, particularly maybe one outside of a major market like DC. But at the same time, because we do this work so often for so many nonprofit organizations, we spend a fraction of the time that many other firms would spend on learning curves and getting up to speed. And so you can't just focus on the hourly rate. The hourly rate is important to make sure you get the maximum fee discounts that you can get built in, but it's not just about the rate. It's about how much time does it take for the work. And of course, the most important thing is what's the value you're getting and how effective is your outside counsel. And those are things that obviously can't always be measured by dollars, but the dollars are important. Any other thoughts?
The other thought on general counsel value is if you're using counsel here and there on things and they don't see the whole picture because you're concerned about it's going to cost me too much, you're going to lose the value. And that general counseling value is they see your whole organization. So if you have vetted and selected the right outside general counsel, they've asked a lot of questions. They continue to be engaged with you, on some level, no cost, like they're wanting to know what you're doing, what you're up to. If you are giving them information, hey, we're having cocktail hour, you're doing things to keep them engaged with you, and you've done something like a retainer, so that you have a feeling that I can call them because this just doesn't seem right, or the board is wanting to take up something at the next meeting. It's going to be a big project, a lot of moving parts. What do you think about it? You're going to get more value out of that. So it gets to the planning issue. I always say take a look at your $990 and see what you're spending a lot of money on and where you're receiving a lot of money. If you're spending a lot of money on quote, consultants, what kind of consultants, what value are they bringing? And say, are we thinking in a creative way to assure we have other types, like IT. Do we have the right IT in place? Do we have the right legal counsel in place? For some reason we're really on IT today, but the idea being, do we have the underpinnings for all the things we want to do, which also always should include some outside counsel, so that you do get the value of general counsel on a more ongoing basis, and it's not just kind of one-off issues.
Yeah. I would always recommend getting a cap for specific projects. You want to do an hourly rate, that's fine. There is no harm in requesting a cap, because hourly rates don't tell you that much, because you can say this is a great rate for a partner and an associate, and then the partner who hasn't been billing that much that year does all of the work, most of which could have been done by an associate, and now you're paying 2 or 3 times as much as you should have, because the associate should have been doing a lot of that research or site checking or whatever that partner was just billing you $600 an hour for. So you definitely, even if you're doing an hourly, you always want to try to get a cap. The other thing I would say is you're two sophisticated entities. There's no limit on what you can agree to. This is a contract. As long as there's a meeting of the minds, you're not doing anything illegal, and the rules of professional conduct don't prohibit lawyers from structuring fee arrangements in very creative ways, except mostly in like criminal cases, personal injury, contingency type fees. So there's a lot of leeway to do a lot of different things. So feel free to be creative. It's not like there is only one way to do things, and if a law firm is not willing to engage you on that, that's a red flag. The cost versus value thing, I just wanted to give a quick example of that, and that is we once hired outside counsel to help us with a major contract dispute that was likely headed to litigation. The partner's billing rate was the lowest, so we hired them. This was not me when I say we, although I was brought in later, and at one point we were going through this and kind of vetting this and preparing it, and I looked at this case, and it was going to have 20 depositions and probably be 20 fact witnesses at trial. So I finally asked, it was maybe a $3 to $5 million dispute, and I asked the outside counsel, start to finish, ballpark it, what is this going to cost to litigate? And he said $2 million. And everyone said, oh. And we suddenly realized what we really needed to do was settle this. So it's good to know at the front, what they think this is going to cost. So you definitely want to know that. And I'm gonna give an answer to the question that Jeff probably won't like, is I will actually give you numbers about what you should expect. And I'm pretty sure they're in line with what you're charging, so that's fine. But realistically, in major markets, you're going to expect to pay somewhere between $200 to $300 an hour for an associate, or $500 to $600 an hour for a partner, depending on what they're doing. Certain areas can be much higher than that. I think if you're paying significantly more than that, that may be okay, but you might want to get an explanation about why. That might raise some red flags. That's generally been my experience for most nonprofits, that we've been able to largely get those rates, even from larger firms, again, depending on what project you're doing. But if you're seeing $800 or $900 an hour from a partner, we do pay some partners that, and that may be fine, but there should be a good explanation about why they're worth that. And you should be getting answers pretty quickly from them. And finally, the last thing I'll say, and this is my last terrible analogy, is that I don't want to refer to I feel reluctant doing this now, but for those of you that watched the Cosby Show growing up or at some point in your life, I know, not the greatest person to bring out right now, but if you remember that episode where Dr. Huxtable takes Theo and they're going car shopping, and he dresses up like a poor person so that the car dealer doesn't know that he's wealthy, so he thinks he'll get a better deal on the car, and somebody rats him out and he sees him. He's like, oh, hey, Dr. Huxtable, and the whole thing is up. If that's how you're shopping for outside counsel, that's really bad. You should be very honest and upfront about what your costs, what your budget is, what your expectations are, what they're going to be able to do for you. It should be a very honest, two-way conversation. And any law firm that can't answer questions very clearly about costs and things like that is not a law firm you want to be doing business with, because it's just going to be a recipe for disaster. So you should be able to have a very frank and reasonable conversation with them about it, even though it's always sensitive.
Yeah, just a few, we got one question back there, but a few quick points on this. First off, the more work that you're sending to a firm, the more that you're using one firm as your primary outside firm, generally the more fee discounts and more aggressive discounting you're going to be able to get. Secondly, alternative fee arrangements have become these days more of the norm than the exception, and like many firms, our firm is no different, where, like Dan said, we have become, and some of our clients have become very creative and flexible in negotiating creative fee arrangements. Another thing that we do often with our clients that helps to keep their costs down is to give them, we have a massive library of kind of model and sample forms, policies, and agreements for nonprofits. And having them, tailoring, sometimes at the outset when we start working with a client, we'll tailor a few basic kind of independent contractor agreements and things like that they can then use as their templates. It means that a lot of those contracts that might otherwise come to us for review don't have to, because they're going to have a lot of those core important provisions and protections already built in. And then a lot of times when things do come to us, it's a lot quicker and more efficient review. So that's absolutely a way that you should work with your outside counsel. It'll help you save a lot of money. And then I think we're going to talk about this on the next slide, but staff trainings on different areas are things that we do quite a bit of in every area imaginable, even a lot of areas where a lot of law firms don't come in and train staff, like on things like copyright and trademark issues, where we'll train marketing, communication staff and things like that, along with all of your typical HR and other things, and federal grant compliance and whatnot. But staff trainings can be another way to really effectively educate the staff in a way that makes it less frequent that you have to use outside counsel. Question in the back?
Yeah. In the standard rate. Oh, thank you. Oh, I don't know if I need it. In the standard rate structure, is there anything for like a free estimate, or what would be considered a free? I mean, because I think sometimes I've heard people say they've had to, go talk to a lawyer and pay for whatever the rates are just to get them to.
No, you should never have to pay for an estimate.
Never ever.
They should be able
no
to,
matter size of firm, whatever.
if a law firm is charging you for an estimate, move on.
And what?
I mean, I've never had any law firm try to pull that with me, ever.
Follow-up question.
Yeah.
How much time do you generally give a client for an estimate?
I mean, it depends. If you're talking about like a prospective client, I mean, I think last week I just had a 45-minute call with a prospective client, and I gave them a lot of legal advice on the phone. I typically do, or not legal advice, but legal education on the phone. And then they're going to go back and talk to their higher-ups and hopefully come back and hire us. And, of course, I also did ask for an estimate on fees, which I gave them. But it really completely varies. But look, if you're working with a firm that's giving you a hard time on that, if they're trying to bill you for estimates, if they're not willing to give you estimates or caps like Dan said, then you may need to consider a new firm. Back here, question.
How do you law firms feel about receiving and having to respond to RFPs?
It happens all the time. Personally, to be honest, I hate it because it's a pain in the ass. They're really, they take a lot of work. I just was on vacation last week and spent 2 hours, granted, on the beach working on a proposal that was due last week. But, they take a lot of time and effort, and if they're well done and really tailored to the organization, it does take a lot of effort on our part. That being said, we've had in our practice, tremendous success in the RFP process, in kind of prevailing in that process. So that does give us an opportunity to really lay out everything in terms of our full breadth of experience and expertise. And so I guess while it's a pain in the neck to put these proposals together, it really is an effective way for our clients and prospective clients to help vet kind of the competition and compare and contrast. The worst one I ever went through, and I'll mention their name because they're proud of it. Lawyers do this to other lawyers. The American Bar Association went through the most extensive RFP process I've ever seen in my life. 2 completely burdensome, cumbersome, super detailed RFPs that we couldn't use any off-the-shelf stuff. We had to write everything from scratch. And it took countless hours to pull both of those together. It's kind of 2-stage process. And then they have a lot of in-house lawyers. They organized 6 different hour-and-a-half conference calls with me and then other key members of our team to go through and ask tons of questions and drill down to make sure we really did have the expertise. They were looking to go from dozens and dozens of outside law firms to ideally 1, and thankfully we did prevail in that process. And they've been a great client for the last few years, but I hope to never have to go through an RFP like that again.
So you're saying that isn't the model to follow?
No, not what I would recommend.
But I would say if you're hiring general counsel, I do think your board or key members of your board should have the opportunity to talk with counsel, and sometimes I think that becomes a disconnect. And I think it's important, and I probably say this more from my experience when I wasn't at the major conservancy but at trade associations. Trade associations really do need to have their members of the board engage in understanding they're taking the fiduciary role in a nonprofit and they are not running a for-profit company. That is a very different thing. And many times they're entrepreneurs, so they are in charge of everything. So sitting on a board being a collaborative process, and that the decisions of the board are the decisions of the board, whether they were crazy about the decision or not, just sort of understanding that puts your whole organization in a better position when you do have to deal with a legal issue because they already have a relationship with counsel.
Yeah, and we've seen many different models. Sometimes the hiring of us, whether it's as primary outside counsel or general counsel, is done solely by the staff. In fact, that happens more often than not with no board involvement. But we do have some where the chairman and or the executive committee or certain key officers do get involved. In fact, I'm going to New York City this Friday. The staff has selected us as their new general counsel, but they want me to meet with their chairman of the board so that he can feel comfortable and make sure that they're comfortable with that decision. And that's not unusual and probably a good idea.
It's good for them to know who you are. So the last topic is we talked a lot about looking at your mission-driven activities, looking at your key assets, and how you're protecting them. And a lot of times it gets overlooked about doing the basics. And organizational basics, which by the way there's a handout in the presentation, I think it's like the last 2 pages. It's the last page where it has all the corporate basics, the bylaws, the articles, policies. Policies need to be reviewed. Are they being followed? Compliance programs, brand management, financial controls. All of those sort of things have implications legally. A lot of organizations get really excited about legal counsel and getting their house in order, and they do that, and their documents are great, and no one ever looks at them again. And that is a problem, particularly with policies and procedures, like conflicts. Dealing with employee complaints. Is the process really being followed? You have staff turnover. You have board turnover. You need to keep those fresh and in the forefront. So one of the key elements I think good legal counsel can do is to provide ongoing training to leadership and staff about those aspects. It does bring a little bit of gravitas, especially if you're not in an organization that's has the luxury of a compliance officer, which is most. Having that be front and center regularly, they see the face of someone, they know this is important to the organization. If someone has a complaint that they didn't know, then you can point to not just the policies and procedures, but the ongoing effort. But I think that ongoing relationship between your organization did all this homework, well, now make sure it stays implemented because it really does help down the line, and practice it. If you have a failure, look back and say, was it the policy or is it the fact that we didn't actually practice the policy? So we're going to go over one last case study, which hopefully will change here in a second. So you have a complaint by a trade association member that wanted to be on the board but they weren't nominated. And they further complain that they think that the chairman didn't want them on there because the chairman is selling services to the trade association. So now you have a high-level executive who's received this complaint. It might be like your director of membership or something like that. That person should know what the bylaws look like, what the processes were for nomination. They should know how to go to counsel. It might be through the executive director, but everybody who's really leading and managing should know those things, because you want to stop and say, how am I going to scope my legal counsel? In the best case scenario, you're of course working with outside counsel that knows you, that helps develop the policies, the practices. But let's say it's not. Then you want to say, okay, get counsel that has expertise in nonprofits, can look at our bylaws quickly, know if we have antitrust issues, did our conflicts policy meet the standard that's now expected of nonprofits, how did the organization make those decisions, and how do you address the concerns of the board, of the member that's not on the board? What is the process for addressing it? That is an example of when fundamentals aren't done, the crisis is the crisis is a crisis versus it's just somebody who's disgruntled, we followed the process, and now what's our approach to keeping this person engaged and understand that the process was followed and everything is fine. And that's why I would say fundamentals shouldn't be overlooked. And having outside counsel work with you on the documents is a good and probably the best step, but the next step is to keep them engaged keep your staff and your leadership really engaged with counsel.
And working with outside counsel, for instance, on that example, that has experience with membership expulsion and suspension issues, that understands the federal tax exemption and the antitrust and the defamation and the other issues that come into play with those sorts of things. And also is familiar with kind of what are common practices, common ways of dealing with this. We've dealt with this issue, for instance, hundreds and hundreds of times, and there are certain tricks of the trade you learn for, and not just from a legal perspective, but how to more smoothly get through this process and how to communicate things and who's going to do the communicating. All of this can have a big impact on the result. And similarly, dealing with conflict of interest issues, which we deal with all of the time. There are some, fiduciary duty of loyalty and other legal issues that come into play, but there's also a lot of non-legal practical advice for how to successfully manage conflicts and help ensure that things don't blow up. And having outside counsel with experience in those areas is invaluable.
Exactly. So that's the reason I don't think the foundation issues should be left on the table. You should know what they are, and like I said, I give you a little short list, but it's the kind of things where how is this organization staying in compliance? Are we meeting it? Do we need a refresher? Do we need maybe a quick desk review? Sometimes auditors, sometimes lawyers. Could we is there someone on staff that really knows us and could be assigned to help us do that assessment so you know where your legal needs are? But don't wait for the crisis, and don't wait for the loss of critical mission-related activity because of something that you cut the budget on, when in fact that's really that's where the soul of your organization. So thank you for joining us for Working Effectively with Outside Counsel.
And one final comment. The importance of educating all of your staff, or at least all of your senior staff, on nonprofit legal issues is very, very important. It can't, even if you have in-house counsel, even if you don't, it can't just be one or two people who are looking out for the legal issues of the organization. You really need to do regular trainings, have your folks come to things like this that are relevant in their different areas of specialty, because they're on the front lines. They're the ones who can red flag the issues and say, hey, maybe we should have a lawyer take a look at this. But if you don't have them well educated and trained from a legal health perspective, you're just not going to be in as good shape. I want to thank Anita and Dan for a terrific presentation. And Dan, wish you the best of luck in your exciting new move. And thank you all for participating. Hope to see you back here next month. Thank you.